respected dignitaries, delegates, honorable members of the Tamil Nadu National Law University governing bodies, alumni of TNLU, participants from all the education institutions, my dearest students and ladies and gentlemen. This is Dr. Amrithalingam, Associate Professor of Law and heading the examination department in the esteemed institution. As we stand at the threshold of virtual gathering, inaugural ceremony, it is time to unfold the horizons of legal history, that is interdisciplinary approach to law, to mark the visibility of TNLU, USP to the whole world. Jnani Palkiwala once said, education at the heart of the matter, literacy is not enough. It is good to have population which is able to read, but infinitely better to have people able to distinguish what is worth reading. The Tamil Nadu National Law University, Tiruchirappalli, is marching towards an extra mile with a smile in the momentous task of molding minds and fields, and glad to inviting you all the virtual inaugural function of the second All India Legalistic Congress, organized by Tamil Nadu National Law University and funded by Government of Tamil Nadu. Now I request all the delegates, participants and guests to rise for Tamil Thai Valtu. Thank you. So I request all the delegates and participants be seated. Now it's time to welcome all our gatherings. A formal welcome is of our tradition and culture and procedure in all the formal events. Ladies and gentlemen, on this present morning, we are honored to have amidst us Dr. M. Sterile, Assistant Professor of History and convener of the second All India Legalistic Congress, to present welcome note to all the gathering. Over to you, sir.
Good morning, Honorable Chancellor and everyone. வருவிருந்து வைகளும் ஓம்புவான் வாழ்க்கை பருவந்து பாழ்படுதல் என்று. திருக்குறள் 83. The couplet explanation goes like this. The domestic life of the man that daily entertain the guests who come to him shall not be laid waste by poverty. It's a great honor and privilege for me to be before your lordship and every one of you to welcome this august gathering. On this auspicious occasion, I welcome from the bottom of my heart our chief guest, Honorable Mr. Sanjeev Banerjee, Chief Justice of Madras High Court and Honorable Chancellor of Tamil Nadu National Law University, Tiruchirappalli. I thank your lordship for accepting our invitation to release the edited book of First All India Legal History Congress and to address this august gathering. We wholeheartedly thank your lordship for spending your valuable time with us in spite of your busy schedule. On behalf of the TNLU community, I welcome your lordship for this second All India Legal History Congress. Welcome, lordship, to this dignified gathering. At this juncture, I extend a warm welcome to the patron of this Congress, Professor Dr. V.S. Elizabeth, Vice Chancellor of Tamil Nadu National Law University, who is the instrument for this mega event in the history of the Consortium of National Law Universities in India. We are very much eager to hear your presidential address, Madam. A hearty welcome to most respected Madam. It's my privilege and honor to extend a warm greetings to our keynote speaker, Professor Dr. Anthony Mushan, Head of Research at Historic Royal Palaces and formerly Director of the Bracton Center for Legal History Research at Law School, University of Exeter, England. Dear Professor, we are really delighted and privileged to hear your keynote address on making legal history in India. On behalf of the TNLU community, Tiruchirappalli, Tamil Nadu, we extend a heartiest welcome to you, Professor. Welcome, Professor. I would like to extend a cordial welcome to Dr. Richard Sharma, Assistant Professor of History, Gujarat National Law University, Gandhinagar, who is the pioneer in forming All India Legal History Association in India to deliver the background to the All India Legal History Congress and the Indian Association of Legal History. On behalf of the TNLU community and on my own behalf, I welcome you, Madam. It's my great pleasure to welcome one of the pillars of this Congress, Ms. K.R. Leela, Senior Civil Judge and Registrar of Tamil Nadu National Law University, who is very supportive in every step of the process of this Congress. We welcome respected Madam for this August gathering. Welcome, Madam. It's my duty to extend a special welcome to all the governing body members, namely members of the General Council, the Executive Council, Finance Committee, and the Academic Council of TNLU for their continuous and generous support towards every step of the growth of this esteemed university. On behalf of the TNLU community and on my own behalf, I extend heartiest welcome to each and every one of the judges, professors, and vice chancellors. Wow. It's an honor for me to extend a warm welcome to my colleagues who are a real and great support to the organizing committee in all the directions. I express my heartiest welcome to all my colleagues to witness this greatest event. Welcome all on this auspicious day. I wholeheartedly extend my warm greetings to all the delegates, including teaching fraternity, professionals, research scholars, and students from across the country, and Professor Dr. Kota Fuki from Osaka University, Professor of Law, for their wonderful contributions and favorable support for the successful conduct of this Congress and witness the same. Heartiest welcome to all the delegates and participants to this mega event. It's my great pleasure to welcome Honorable Thiru S. Raghupati, Minister for Law, Court, Prison and Prevention for Corruption, and Pro-Chancellor of Tamil Nadu National Law University, Tiruchirappalli, and the representative of Tamil Nadu government. Without their financial support, this Congress would not be possible. Welcome all. I extend a warm welcome to the administrative staff of the TNLU community, and most particularly the IT support and all the staff for this memorable occasion. Without their continuous support, this successful event would not be possible. Welcome all. I welcome all the vice chancellors, professors, and delegates from across the country. Last but not the least, I wholeheartedly welcome all the lead speakers and chairpersons across the country and globe for their continuous support and fullest cooperation throughout this second All India Legal History Congress. Welcome, professors. Once again, I extend a warm and hearty welcome to each and every one of you. Thank you.
Thank you, sir, for welcoming all the delegates and guests. It's indeed my pleasure to invite Dr. Richard Sharma for briefing the background of the All India Legal History Congress and the Indian Association of Legal History. A brief profile of Dr. Richard Sharma. Dr. Richard had completed a UG, PG and doctoral program from MS University, Baroda. Currently, she is an assistant professor of history, senior scale in Gujarat National University, Gandhinagar. Dr. Sharma had attended different centers, including Center for Legal History and Center for Sports and Entertainment Law. Dr. Richa had completed many projects, including she had traveled many countries and she is a visiting fellow in 5 different foreign universities. Above all, Dr. Sharma is pursuing degree course Sanskrit in Dharmasastra from Baroda Sanskrit Mahavidyalaya, Vadora. With this brief introduction, let me invite Dr. Richard Sharma to give a brief outline about the background of the Congress. Over to you, ma'am.
Good morning. Thank you very much. To begin with, I would like to quote Eric Palanen first. Steady and ready, ready. Gilbert said, nothing shall sway away my confidence. Namaskar and very good morning, Honorable Mr. Justice Sanjeev Banerjee, Chief Justice of Madras High Court, Professor Dr. Anthony Mason, Head of Research at Historic Royal Palace and former Director of the Bracton Center for Legal History Research at the Law School University of Exeter, Professor Dr. Elizabeth, Vice Chancellor and Patron of Second All India Legal History Congress, Ms. K.R. Leela, Registrar, TNNLU, Dr. Brito Stellan, Assistant Professor of History and Convener of Second All India Legal History Congress, ladies and gentlemen. Welcome to Second All India Legal History Congress. I have been assigned a task of introducing Legal History Congress and Legal History Association to this majestic gathering that is presently witnessing the inaugural session. I thank Professor Elizabeth and organizing team for having me to give a brief overview of my experience as to how the event and association was coined by a subject teacher. While teaching history over a decade, I started feeling close association with the subject. My passion to learn more and bring something more relevant and new to class started increasing day by day. I always tried to bring best of available knowledge in my classroom and seek solution to present day legal issues from history. While conducting an in-depth research, I came across well-established Legal History Association in the United States and Europe, which are engaged in conducting substantial studies in documenting their legal history, and it has been used tremendously by lawyers community to find solution to present-day legal problems. I tried to ferret out any similar organization at Asia level, but surprisingly, the engine was yet to be invented. With the assistance of Osaka University, Japan, and Professor Kota Fukui, I tried to build an association, but soon I realized that there is a lot to be done first at national level. Looking towards India, after having integrated 5 years law courses, we have developed a culture of teaching legal history as a subject. And we got series of good books written and published at initial stage. But in due course of time, research in legal history took a backseat. Neither government nor universities paid much attention to encourage historical inquiries into legal past of India. It seems that Legal Fraternity of India had accepted altogether Western notion about legal heritage of India with more of its limits and praise associated with the unification convergence of law during colonial and post-colonial era. Teaching of legal history of India got heavily dependent upon British rule and the development of state law. State law with welfare legislation that took place during the period. There are quite a few professors whose research and writing I used to read and quote in classroom, but I soon found that there was an ample scope and various versions of law available, but not being deliberated, discussed, exchanged, and documented in a common forum. I realized legal history and historians were and are in need of a public sphere to share their research and exchange ideas by going beyond colonial and post-colonial national legislation. Learning associated with non-state law of India, learning associated with regional custom prevailed and sustained. Learnings on various alternate dispute resolution mechanisms prevalent in South Asia and learning causation of law and identifying ancient and medieval jurisprudence of India is need of a present to understand our legal pluralism. Going beyond trial and error method of lawmaking, we need to learn and understand interplay between law, history, and economics. And we need to learn what can be understood as social constitution in time and space. In the same spirit of learning, the Legal History Association was set up during the first All India Legal History Congress held in February 2020, with the vision to initiate legal history research movement and to conduct in-depth inquiry into Indian legal heritage and identify possibilities of vertical transplantation. Today, this passion of learning from each other has made us united and has brought all of us together under one virtual roof. I'm extremely thankful to legal historians, especially Professor Dr. Elizabeth Mitra Sharafi, Brenda Lizaffer, who always guided, helped, and in crystallizing the idea of organizing All India Legal History Congress and create an association to bring each and every person interested in legal history to share and document their respective research. Through this Congress, I hereby invite all the delegates, participants, and chairpersons to join the meeting of Legal History Association scheduled on 22nd May at 1:30 p.m. IST to contribute and be part of this noble mission to preserve legal heritage of India. Before I conclude, I thank you all and I am looking forward to a very engaging and fruitful 2 days conference. Thank you very much.
Thank you, ma'am, for your invitation and highlighting the background of the All India Legal History Congress and the Indian Association of Legal History. Thank you. It's time to honor and welcome one of the great personality both in Tamil Nadu National University family and the judicial system of Madras High Court. On this present morning, we are delighted to have an eminent and intellectual personality who had described that I am a judge first and a Chief Justice later. The early life of our Chancellor and Chief Justice of Madras High Court, Honorable Justice, begins his birth of 2nd November 1961. Lordship started his schooling at Calcutta and Darjeeling. Lordship was BSc with honors in economics in the year 1983 and acquired his LLB in the year 1986 and 87, both from University of Calcutta. Lordship was enrolled as an advocate on 21st November 1990. Lordship has practiced principally in the High Court of Calcutta and the Supreme Court and tribunals, primarily in law branches. Lordship has specialized in civil, company, arbitration, constitution, and intellectual property law matters. Lordship was elevated to the bench of the High Court of Madras at Calcutta as a permanent judge on 22nd June 2006. Lordship was appointed as the Chief Justice of the Madras High Court and assumed the office of the Chief Justice on 4 January 2021. Realizing the social concerns, His Lordship has delivered judgments in matters encompassing almost all branches, including important public interest litigations. It is notable of him that His Lordship is one of the gender-sensitized judges in the legal fraternity and have strived to uphold gender justice throughout his career. A couplet from Tirukkural, Idanai Idanal, Ivan Mudikum Yendraindu, Adanai Avan Kan Vidal. Meaning, after having considered this man can accomplish this by these means, let the king leave with them to discharge of their duty. We, the Tamil Nadu National University family, is privileged to have His Lordship as our Chancellor. With a few words, I request His Lordship to release the edited book of selected papers. Please, Lordship.
Vanakkam and good morning, Brother Sivanamyam, Mr. Tatar, Vice Chancellor Dr. Elizabeth, Professor Masoon, dignitaries, students, ladies and gentlemen. I have the privilege of releasing the book which makes for very interesting reading. It's edited by Dr. Richard Sharma and covers legal history and various aspects. It has an article, a rather interesting article on the evolution of the Indian jurisprudence. It has an article on Dharma. It has an article on South Asian legal history and customs, and is very interesting reading. I congratulate Dr. Sharma for this venture and commend the book to everybody.
Thank you, Lordship. So now I request your Lordship to deliver your Chief Guest address to the gathering. Over to you, Lordship.
Since the pandemic has overtaken our life, I begin by referring to it and a sense of humbleness that it brings about. We must realize that our inflated egos need to be lessened a bit. We must realize that we cannot fight with nature. We must realize that we must coexist with nature, with plants and animals, and that we cannot appropriate this entire planet for ourselves. Since history is the flavor of the conference, I will refer to one aspect of history that we follow as we go about justicing and in our courts. But let me preface my address by saying that in most cases, judges get the credit for enunciating a principle or laying down a particular proposition, but more often than not, the actual thought or the imagination stems from a lawyer who puts it in course of an argument which is picked up by the judge and reflected. Sometimes it's polished a bit, sometimes it's refined, modified, but the contribution of the lawyers in how the law has been laid down and developed is immense, and judges should not take sole credit for it. The second aspect is there is need for a degree of humility in judges because we deal in several aspects, but we cannot be all-knowing, nor should we pretend to be all-knowing. There are some branches in which certain people, judges, may have had more experience, may have worked as lawyers, And in these areas, the concerned judge may expand the horizons or may speak on the ancillary and incidental aspects and develop the law. But in certain other matters where the judge lacks the academic depth, he should probably be just deciding the list and not seeking to deal with the law too much. This is very important in judges, because we find that the position that a judge occupies, particularly in our system, gives him an inflated ego, as if he is a master of the field that he is dealing with, when in all fairness, he may not be one. The aspect that I wish to deal with today, and that aspect of history pertains to the precedents that we follow in our courts and the law of precedents. Law requires, and particularly law as applied in courts requires, two things more importantly than any other. Apart from timeliness, which we currently lack in and need to improve, and there are various reasons that I need not go into, law requires a degree of certainty and an element of finality. Certainty, because future human conduct or how people act in a particular set of circumstances need to be guided by how the law has been read or laid down in that area. And finality, because matters have to end at a particular time. You cannot go on repeating, reviewing, preferring appeals and dragging it. In fact, that is one of the banes of our system. So we have the principles of, where the rule against double jeopardy, and even in civil law, you have constructive res judicata, which implies that you had not urged the ground that you ought to and you could have, then you are precluded from raising it at a later stage. The doctrine of the rule of precedence that we follow, and where history is important, stems from the Anglo-Saxon jurisprudence that we inherit and the common law system that we follow. Anecdotally, common law originated from the various communities, the clans which were there in England and settled in England after the Norman invasion. And some of these clans had some rules of their own. So whatever was common, the common rules or principles applicable to the various clans became the first source of common law. And it's mostly judge developed and not codified, so to say. And in common law countries to which we belong, the rule of precedence plays an important role. There is the doctrine of stare decisis, which is that if a particular interpretation to a particular principle has been in vogue for a long period of time, it should be allowed to rest unless there is a complete change in circumstances which requires it to be reworked. The rule of precedence, together with Article 141 of the Indian Constitution, makes the law as declared by the Supreme Court to be the law of the land, and it has primacy, it is binding. And Article 144 of the Constitution requires all institutions to come to the aid of the Supreme Court in implementing the law and enforcing it. Now, increasingly, because the Supreme Court has several benches, and because high courts are bound by Supreme Court judgments, and there are minor differences in Supreme Court judgments. In the High Court or at the High Court level, there is a difficulty in which one to follow. Now, the rule is very clear that the judgment of the Supreme Court in the hierarchy of courts that we have is binding on the High Court. But if there are two judgments of the Supreme Court which are somewhat at variance, then for the High Court, it has first to decide which of the two is closer to the facts of a particular case, the list which is being decided, and which of the two principles apply closely to the law required to be decided in that list. If even after that there is some conflict found in the two judgments, then the High Court is entitled to take what, according to the High Court, is the more suited or the better reasoned judgment. Of course, there are certain caveats to such rule, that if a previous judgment of the Supreme Court has been noticed by a subsequent judgment of the Supreme Court and has been interpreted by the subsequent judgment, it's the subsequent judgment which is binding, despite it appearing to the High Court that the former judgment is somewhat different from the later judgment. The rule of choosing applies only where the former judgment is not noticed by the later Supreme Court judgment and there is an element of conflict between the two. Similarly, in our courts, in the High Court particularly, the division bench judgment is binding on the single judge, and the single judge cannot disagree with a division bench judgment. It is only when there may be two conflicting division bench judgments and one does not notice the other that the single judge may then refer the matter to the Chief Justice of the court for a larger bench to be constituted to reconcile the difference between the two sets of judgments. There is also another aspect. Though the division bench judgment of the High Court is binding on the single judge, if the division bench judgment is contrary to any principle laid down by the Supreme Court, then it's the principle which is laid down by the Supreme Court which becomes binding on the single judge, and the division bench judgment is no longer of any effect. In fact, that gives rise to the principle of per incurium. Per incurium literally means in ignorance of, but the doctrine of per incurium applies even if a particular position which is taken in a previous judgment has been altered by a hierarchical superior forum at a subsequent stage. The law declared by the division bench of the High Court in that case ceases to be good law. As far as the district judiciary is concerned, it is the law on a particular legal aspect or proposition which is laid down by its parent High Court that is binding on it, unless such law as laid down by the parent High Court is found to be in conflict with any judgment rendered by the Supreme Court on such aspect. There is, of course, an art in finding out what is the legal proposition laid down by a judgment. As we all know, and it's now become a cliche, that the life of law is not logic, but experience. In fact, there is this famous passage from Quinn and Latham, rendered at the turn of the previous century, that I wanted to read out, but I don't think I should. The principle is well known. And the effort should always be to discover what is the ratio decidendi in a judgment. And the legal proposition has to be discerned by looking at the facts and the law decided in the milieu of the facts in that particular case to discern the legal proposition. In fact, while discovering what is the ratio decidendi, one must always be aware of the obiter dictum and what passes sub silentio. Though for a forum at the bottom of the pyramid, even the obiter dictum of a superior forum has great persuasive value, but it may not be binding in a particular set of circumstances like a ratio decidendi is. Similarly, what has actually been decided is the ratio decidendi and not what can be inferred to have been incidentally decided. The proposition as actually laid down in the set of circumstances is the ratio decidendi. And for many, it takes a lifetime to discern what the ratio decidendi in a particular judgment is. Of course, law, if it aims to bring about social order and regulate the conduct of human behavior in society, takes a lot from history, and we in the courts also take a lot from the history of the law. Indeed, when applying the law, we have the books open in front of us so we can refer to the law, but it's always advantageous if we have the education and the background history of why the law came to be the law in that area. Once you're aware of that, once you're aware of the history behind how law in that aspect was written, you are more adept in dealing with the various problems that arise in interpretation and application. In a sense, law is always playing catching up. The criminal is one step ahead of the law, and in most cases, legislation is a reaction to criminal acts or acts which are otherwise considered not to be appropriate for larger public interest or in society's interest. The exercise that we perform in court is one of justicing, which has to be done according to the constitutional ethos, keeping our personal predilections away from the judgment-making process. Of course, we also exercise appellate jurisdiction, and appellate jurisdiction is also divided into regular appeals where facts and law can be dealt with, or appeals on questions of law which are of restricted nature. We also exercise judicial review in our supervisory jurisdiction in the high courts and in the superintendent jurisdiction. The quality of adjudication, the nature of assessment depend on the purpose of the process, and it's the integrity of the process and the purpose of the process that has to be kept in mind, keeping the applicable law, the history behind the law, and applying precedents as the historical basis in how law has come down and interpreted by courts. I thank all of you for giving me this opportunity to be in your midst. I do not claim to be an academic. My only claim is my 15 years experience as a judge, both in Calcutta and in Madras. In course of being a judge, you have to take matters which you may not have practiced in, and over a long period of time, you deal with matters that you had no connection with as a lawyer. That is the experience from which I speak without claiming any academic excellence or the level of erudition that some of our professors possess. I wish you all very well, stay safe and healthy, and I hope we can meet after the pandemic with a smile on our faces. God bless you. Thank you.
Thank you, Lordship, so for our enlightening speech. Indeed, our pleasure to great words by great minds. So we, the teaching faculty, we will take a precedence and the application of racial dissent in all the teachings. So time and again, Manunidhi Cholan is remembered while delivering justice by the judges of the country. Having read all the ideal judgments pronounced by Honorable Justice, I would like to describe our justice as a legendary of Chola king, who is the epitome of an ideal judge. All the contribution of the Honorable Justice will be remembered and followed by all the personalities who are causes for the administration of justice in the country. Thank you very much, Lordship. Now, it's time to invite. So, keynote speaker, we have amid us Dr. Professor Anthony Musen. Professor Anthony Musen studied as an undergraduate at Cambridge, where he was also a choral scholar in the world famous King's College Chor. He went on to gain a doctorate there in medieval legal history before qualifying as a barrister of the Middle Temple and being called to the bar of England and Wales. Professor Musen was the faculty member in the law school at the University of Exeter for nearly 20 years. He is also a director of the Proctor Center for the Legal History and Research. Professor joined Historic Royal Palaces in 2018 to lead and foster a distinctive vision for the charity research into holistic places, diverse communities, landscapes, and collections. As the head of the Research Institute, Professor is responsible for encouraging innovative initiatives in heritage-based research, its interpretation and presentation across for all the historic royal palaces departments. Professor Musen has written several books, including The Evolution of English Justice, Medieval Law in Context, Crime, Law and Society in the Middle Ages. Professor also edited several books. He had extensively published on Magna Carta, medieval criminal justice, the legal profession, and on visual representation of law and justice. Professor Musen is a fellow in the Royal Historical Society and the Society of Antiquaries. Professor is holding various international fellowships to India in 2002. He had visited and instrumental for setting the exchange program with the National University of India School, Bangalore, and gaining accreditation for excess LLB from the Indian Bar Council. With this brief introduction, let me invite Dr. Professor Anthony Musen to deliver his keynote speech. Over to you, Professor. Professor, please unmute yourselves. Professor, please unmute. Yes, Professor. Now we are here. Thank you, Professor.
Good morning, everyone. I'm deeply honored to be giving this keynote address at the All India Legal Congress today, and would like to thank Vice Chancellor Professor Elizabeth for her kind invitation. I'm only sorry that I cannot be with you in person in Tamil Nadu University today and enjoying your excellent hospitality. The global pandemic that has hit your country particularly severely in recent weeks has affected ways of working and socializing, and also institutions, restaurants, and shops in ways that we never thought could happen. But things such as the internet have also brought us together. So as I say, I'm pleased to be able to speak to you from England about making legal history in India. When I first conceived this title, I considered taking a series of causes célèbres, leading cases that made splashes in the press that had a particular impact on the law in India, and that from an outsider's perspective had something to say on a higher level about the law and the way it has been consumed and presented over time, examining essentially what made it a particularly Indian legal history. Then I thought, given the theme of the conference is about legal history in the 21st century, that it might be more appropriate, rather than looking solely to the past, to consider what legal history in the present and future should be trying to do. In other words, present a vision for legal history and suggest what impact it can make today, not only on the law and legal institutions, but on the legal profession and legal education. In so doing, I'm advocating a special role for legal history, not just in helping us to understand the past, but how that can help interpret the present and even predict the future. In the course of this presentation, therefore, I'll be setting out approaches and methodologies both for researching legal history effectively and for making an effective legal history, a legal history that counts for something, has purpose and benefit. Legal history is often written and used without realizing its potential and its implications, which need to be followed through. Before I examine how we can make an effective legal history for India, first I want to ask two questions. What legal history and whose legal history? There is probably no other country with such a diverse and rich legal heritage as India, or with such a complex patina of intertwining laws and customs. Its ethnic and religious mix, its previous immigrants, invaders, and rulers have all influenced it for good or ill, sometimes imperceptibly, in other ways more overtly and profoundly. India's vastness and distinct geographical regions, all with their own traditions and experiences, have a distinct impact too. And this is reflected in the sheer variety of papers being presented at this conference. This Congress is all India, not just in terms of the country's geography, which influences any attempt to coordinate and research its legal history, but in relation to its multi-layered history, and ideally too, in terms of its social inclusivity. Law conceptually and practically permeates every aspect of human life, interaction, and development. Link that with legal history, and the research dimension is huge. Ideally, you must examine everything from every angle, or at least you have to consider it. If so, you need a methodology to achieve this. Indeed, you can look at it in different ways with different methodologies. You must also be objective and aware of the biases and personal motives that can drive research. Adopting a particular perspective, be it critical or feminist, is laudable and necessary for a questioning of the status quo, but should not blind one to the wider spectrum and the historical realities. Contextualization is key. An effective legal history is more than a magpie picking and choosing from other disciplines as it feels appropriate. It is capable of absorbing these and producing its own hybrid for understanding the world under the law. So in order to release its full potential, we need to recognize that the subject matter of legal history must be treated as holistic law and be inclusive. Legal history is multidisciplinary, interdisciplinary, and transdisciplinary. It is multi-layered and multifaceted. It is broad-ranging in its scope as law, but even more than that. It goes where law goes, but goes beyond that because it has a historical dimension. It goes into the application of law and converging with legal theory,
discussion வந்துச்சு தமிழ்நாடு
even
law
into the
university
historical dimension. It goes into the application of law and converging with legal theory, even into the hypothetical of law. Legal history also engages with those who come into contact with law at all levels: professionals, government, legal institutions, those subject to it, those who write about it in literature, those who draw or paint it, those who recreate it or enact it dramatically. Legal history, therefore, is not just about the legal environment, but entertains an understanding of people and of the human mind, the psychology of law, as well as the lived experience of diverse societies, the anthropology of law. The problem is, however, that legal history is so inter and transdisciplinary that either people don't realize that, or the task is so massive, it is impossible to research thoroughly on one's own, or with only a small group of like-minded researchers. There are European projects that seek to provide a complete legal history for a particular topic. For example, a project I was an editor for on the transmission of Western legal culture through the phenomenon of the printed book, or a super history of higher courts within a particular jurisdiction over time, again, something I contributed to, or something that looks at legal transplants within a particular area or country. There is also the snapshot approach, trying to capture the essence of the legal history of a country through its legal and quasi-legal activities, drawing on the legal records of every type of court for a single year. This is very much reliant on the availability of the sources and still circumscribed in its outlook. So if we acknowledge the breadth of the subject matter of legal history and the enormity of the task, how can it best be tackled to make it effective? I want to propose that 4 ways in which this can be done. Is acknowledging the multi-layered, multifaceted approach, entertaining a collaborative approach, embracing technological advances, and ensuring there is an education of law and history students. So to begin with the multifaceted approach. As background to this, the limitations of existing approaches must be understood. Currently, the 2 major approaches to legal history research are doctrinal and socio-legal in nature. They exist at almost antithetical poles and provide relative discourses, but do not tend to meet or interact. The principal shortcoming of traditional doctrinal approach is its narrowness. It addresses only the rules of law, their nature, development, and reform. As such, it is inevitably and inherently highly technical in both content and language. It allows no broad brush approach, no generalizations. Every proposition has to be carefully weighed, considered, and argued within the strict bounds of the law itself. Accordingly, a thesis can depend on the interpretation or construction of one word or phrase, or the juxtaposition of several. It is a highly delicate, specific, technical analysis of the written word within well-known and ancient principles of thought and reason. It is esoteric research in a rarefied atmosphere. Such an ethos inhibits creativity and criticism outside the strictly legal field. The reason for the initial formation of the law is rarely investigated, its existence forming both the starting point and focus of the subsequent study. Similarly, any examination of its context tends to be limited to its legal context. It might address problems of interest to the legal practitioner, but confines its attention to problems of a legal nature. While it assesses the value of legal rules within the specialized field, it does not question the wider value that may obtain. Wider contextualization may be deemed unnecessary or irrelevant. Indeed, it may modestly be considered outside the sphere of the researcher's expertise. The doctrinal approach makes the law itself not only the focus, but the whole subject of this type of legal history. The self-referential analysis and the absence of contextual perspective results in a legal history of value to and accessible only to lawyers. The socio-legal approach which developed its own intellectual tools to address these shortcomings, succeeded in broadening critical legal scholarship, and eroded erstwhile inhibitions between law and cognate disciplines. It offered new and exciting perspectives for legal study. The new discipline, however, quickly outgrew its original intellectual boundaries, and its desire to achieve a comprehensive contextualization. In embracing the models, terminology, values, and theories of the new social sciences, the socio-legal approach in its extreme forms has become as intellectually inaccessible and as exclusive as the doctrinal approach. The socio-legal approach has allowed context to dominate at the expense of law, and the absence of any underlying rigorous legal analysis makes the approach of limited value to the lawyer. The legal issues have become too diffuse to afford the lawyer a point of reference, to allow him to engage or her to engage with the wider discussion or to focus on the essential legal issues. Explanation of the surrounding context is couched in the jargon of the social sciences and employs statistical data, much of which is alien to lawyers. The absence of any familiar legal landmarks, therefore, and the style and manner of delivery frustrate the legal reader. Neither is this approach wholly appropriate to the historian who appreciates the importance of law and seeks an interpretation of its historical context. The tendency towards generalizations across broad time periods may provide an interesting overview, but can lack the specificity necessary for more detailed historical analysis. The opposite tendency to microcosmic study is equally unsatisfying. Finally, the thematic straitjacket of socio-legal discourse is perceived by historians as too prescriptive in nature. The understanding of the law itself and its full legal context, combined with an appreciation of the social and economic influences and the effect of the law, are essential elements in the construction of an effective legal history. Both lawyers and historians, it is suggested, demand technical legal rigor and an accessible contextualization. And it is this the effective approach provides. It is necessarily multi-layered and multifaceted in conception, yielding a variety of discourses and interpretations. This requires the examination of the law itself and its dynamic force in the various environments in which it operates. It demands specific and general historical perspectives in the sense that the operation and impact of the living law must be assessed both in its immediate historical position and within the broader expanse of the historical continuum. This methodology addresses and incorporates the reality that law conceptually and practically permeates every aspect of human life, interaction, and development. The outcomes of such methodology are sufficiently uncolored to allow scholars to use them to inform their own perspectives and objectives. I'm not saying that it is a prescriptive or should be slavishly followed. It is a process to be borne in mind, and one which is intended to inform the researcher and which then enables them to join or jump off at the appropriate point. The point to grasp is this, that this is a multi-dimensional continuum, and the researcher needs to understand how and where they situate their own piece of research within that. This is particularly apposite for those who are not legally trained or lawyers who are not historians. The effective approach maintains the content of the law, by which we mean its rules and procedures, is not only the starting point in making legal history, but must itself be examined and tested in its own right. The first layer, therefore, comprises an informed analysis of the rules of law in question. This would involve the identification of the particular rules applicable to the issue under examination. The relative difficulty of this will, of course, depend on the clarity and definition of the subject and will necessitate recourse to the formal sources of law. There may at this stage be problems and limitations as to interpretation and construction, and possible internal conflicts between a number of rules appearing to relate to the issue. In practice, the greater specificity of the issue, the easier it is to address and resolve. While the legal rules themselves are often superficially clear in their meaning and intent, there is frequently and considerable difficulty in relating them to the underlying general principle of law. There may be an interaction of several principles and the rules of law arising from them, and not necessarily in the same branch of law. Only rigorous analysis completes the jigsaw of legal theory. If the piece does not fit, the argument may be misconceived or may create an exception, which then may need explanation and justification. This next aspect of the analysis is its placing in its immediate legal context. The status of the rule under examination, as statutory or judicial, requires consideration and the application of the rules of statutory interpretation or of judicial precedent, as we heard about just now from the Honourable Chief Justice. In turn, the impact of these must be evaluated. The issues arising from case law can be particularly opaque, as for example, where there is no definitive ruling from a higher court, and the researcher is confronted with a number of differing decisions of equal authority. The nature, extent, and reasons underlying judicial distinguishing of an earlier case law must in such instances be carefully scrutinized. Again, a decision may appear clear and authoritative, and yet on closer examination, it might be found that the majority view expressed as the case progressed through the court hierarchy is in fact contrary to the final decision. An individual judge who himself has moved up the judicial ladder may have accompanied the case through its various stages. Indeed, may have changed his view in response to the arguments of counsel or his own personal inclination. Where the rule of law under examination is statutory, care must be taken to avoid its adoption at face value in isolation from its judicial interpretation. Furthermore, judicial rulings on statutory provisions require close investigation, since a judge's preference for a particular rule of statutory interpretation may affect the outcome of the case and accordingly the resulting rule of law. Having considered the rule in the context of its own specific branch of law, and having placed it in the judicial or legislative schema, its relationship to the other branches of substantive law must be addressed. Their principles may overlap and inform the application, scope, and effect of the primary rule. A further element in constructing the legal context of the issue in question is the identification of the field of operation in which the rule is intended to take effect. This brings the researcher away from the conventional classification of English law into property, tort, contract, and so forth, and into a comparatively recent categorization, embracing such fields as social law and economic law, which draw on a number of traditional branches. An issue which falls into one of these wider categories must be analyzed according to strict legal principles. The researcher must be aware that in its nature may result in a particular treatment in courts of law. Furthermore, its nature as, for instance, social or economic legislation may be central to its wider non-legal contextualization. There is yet another dimension to the legal contextualization. It is important to consider the absorption of substantive legal matter within operational judicial arena. Any legal rule or proposed regulation must, by its very nature, have a reality beyond its theoretical domain. This involves an examination of the law from the point of view of its implementation and requires the resolution of a number of essential questions. For example, whether there is a dichotomy between the intellectual understanding of a law and its practical sphere. Again, the researcher should ascertain whether the value of a rule is necessarily diminished by its difficulties in or impossibility of enforcement or practical application. This may be of particular advantage where the legislator or judge is striving to fulfill an ideal, as in those branches of the law which are based on such concepts as honor, moral obligation, and confidence. In certain fields of law where enforceability is paramount, a regulation which does not achieve this aim may be deemed worthless. The legal contextualization must include consideration of the role of legal practitioners themselves. Their reception of the law, illustrated by their treatment and application of it, is significant in itself, and may also reveal or be affected by factors such as their social background and religious beliefs. The law's educational dimension and its intellectual domain, including the ethical context, provide a further perspective which is frequently overlooked. I will return to this in due course. A full legal contextualization prepares the ground for progression to considering the relationship of the law to other spheres of human activity. In this respect, the identification of key disciplines is essential in order to address the full range of issues raised, possibly unexpectedly, by the comprehensive legal study. Researchers should be encouraged to consider the social, economic, political, religious, ethical, and intellectual dimensions of the law, as well as their interaction and interrelation. The influence of extra-legal activity and conditions on the formation of the law is of particular importance. For example, political policy may initiate legislation and affect judicial reasoning, and political ideology may dictate a pattern of law making and enforcement. Again, social conditions may make particular legislation imperative, or indeed may render reforming legislation ineffective. Economic policy and performance are especially potent and pervasive in the creation of law. Moral and religious influences on lawmaking may be more difficult to perceive, but can be significant determinants of legal development. An understanding of philosophical trends of thought and intellectual discourse would be essential to the appreciation of lawmaking in certain jurisdictions. The methodologies of psychology and psychoanalysis offer insight into the creative and receptive aspects of legal thinking and the operation of law. Similarly, the models of cultural and social anthropology and sociology in its pure form enlighten legal history research. It is equally important to an effective legal history to take account of the effect of the law so formed within the broader framework outlined above. The effect can be diffuse or focused, short or long-term, or perhaps even illusory, and accordingly needs careful analysis. Indeed, the extent to which law may determine, control, influence, facilitate, or reinforce specific activity is revealing. This approach emphasizes the permeability of the boundaries of cognate disciplines and the intricate relationships between them. But the effective approach requires a strengthening of the historical context to legal history research. It seeks to promote historical insight and understanding. Traditional methodologies have been concerned with legal history rather than law in history. The latter concept is significantly broader than the former, in that it demands that law be considered not in isolation, but in relation to other historical factors. In so doing, it refuses to make the assumption that law is necessarily the principal factor, or even an equal weight in determining an historical trajectory. Indeed, the law may be a minor and insignificant factor in a superficially legal context. The importance accorded to such relative values reveals a different perspective, embracing innovative comparisons which are truly interdisciplinary. It may also be advantageous to adopt a perspective independent of one's primary discipline. The aim is to allow the law to find its true place in the historical framework, rather than to construct that place artificially. It is therefore possible to assess the importance of the law within the whole picture of legal history, the whole picture of history, rather than simply to assess its introspective significance. Location of the law within a chronology requires consideration of its immediate and holistic context, as well as its broader chronological sweep. The detailed examination of the contemporary operation of the legal rule or law yields essential information as to its success, failure, utility, or influence in the lay and professional perceptions of the time. A wider chronological perspective, with the benefit of hindsight, yields an appreciation of the degree of endurance or transience of the legal element, and crucially an understanding of the broader historical significance. The perception of the historical players must not be overlooked and may provide valuable insights. The discipline of the doctrine of judicial precedent, as we heard, which lies at the heart of the common law tradition and the rigorous dating of legal sources, encourages slavish devotion to an incremental chronological progression. This in turn inhibits full contextualization and masks the nuances of the historical representation. The placing of law in the constructs of history is central, therefore, to the effective approach. It is within this context that the problems and limitations, but also the possibilities of the sources arises. The historian tries to weave a complex tapestry from the myriad strands of evidence, some incomplete, some fragile, and some more robust, in order to create an accurate picture of the past. Such a picture may be difficult to create, since historical sources are not always evident and may be inaccessible or non-existent. This is particularly so the further back in time one goes, and in relation to different societies for whom literacy and/or documentary culture may not be evident. That does not demote or invalidate the legal cultures which rely on oral transmission or non-text-based sources of law. Because of the inherent need for procedural and substantive certainty, the traditional legal sources are generally self-evident and virtually incontrovertible. Law as an evidential resource, therefore, has a tendency to dominate the scene. An early appreciation of the risks of this imbalance minimizes any distortion of the historical picture and enables the accurate interpretation of the evidence. The effective approach embraces not only the traditional formal legal documentation, but also an unprecedented interdisciplinary range of sources in the making of legal history. The legal sources should not inhibit the comprehensiveness of the research, and sources should not be dismissed lightly because of their apparent irrelevance. The effective approach depends on the critical analysis of a wide range of documentary material, whose relevance to law may not always be self-evident. The first recourse at this stage of the research should be to private archives containing collections of correspondence, diaries, and other family papers. International, national, and local contemporary newspapers and popular journals can provide background information and comment. Biographical detail may be invaluable in forming the analysis even of formal law, as for example, the personality, background, beliefs, and interests of a particular judge may well explain certain aspects of his decisions. Researchers should be encouraged to look beyond such traditional sources to take account of the resource of other disciplines. Literary works such as poetry, plays, and novels offer a cultural, historical, social, and popular context, and accordingly new and interesting perspectives on the extent of the reception, understanding, and expectations of law. In this respect, musical plays, songs, ballads, hymns, and ditties play a part in recreating an effective picture of the past. Theological works promoted the concept of rules of behavior and their relationship with the divine law in an ordered world. Holy books and leading theological critique are accordingly a prime resource. Case studies in anthropology, psychology, and sociology also provide their appropriate perspective. The holistic approach to sources, which is central to the adoption of the effective approach, necessitates the study of non-textual materials. The use of image to inform legal history research has been neglected by traditional methodologies. This particular genre of source yields an abundance of fruitful avenues and may, in the same way as textual sources, be distinguished as being formal or informal in their character. Formal legal images, such as the court architecture, judicial dress, and official rituals and symbols, visually express the values of the legal establishment and their promotion. The existence and observance of rigid codes of court etiquette is equally revealing. Informal legal images, such as legal portraiture and cartoons, provide an informative background as to the perceptions of the operation, substance, value, and personnel of the law. Again, the value of drama is not limited to its textual expression, since it can penetrate the consciousness through its visual impact in the medium of plays, opera, films, and television. There is a danger that I will be accused of setting legal history up as something impossible, as too ambitious, as too broad, a methodology that can't be achieved. That would be true if the old model of the lone scholar or of small groups from within an institution were followed. It is obvious that it is not possible for one person to do all this, but combinations of legal historians could. Given the multitude of assembled delegates for this Congress, there is scope for collaboration on a broad scale. for groups from a number of different universities getting together to investigate legal historical subjects. Indeed, given I'm advocating legal history is multidisciplinary, interdisciplinary, and transdisciplinary research. Research should involve those from specialized disciplines who are not necessarily legal historians themselves, but are capable of providing an understanding and interpretation from their point of view on the topic. Linguists, art historians, philosophers, sociologists, anthropologists, geographers, even evolutionary scientists, all could be brought on board to provide a true meeting of minds. This may be happening to a certain extent. There has been funding for projects within the European Union specifically to broaden the horizons of research and ensuring collaboration based on a prescribed number of countries participating in the project in order to qualify for funding. This may be the case in India too, and definitely ought to be. An all-Indian perspective on legal history would greatly benefit the subject. Yet there is no reason why those who work on Indian law and history from outside India couldn't be participants. In the interests of global participation, for which there are now some limited funding schemes, those scholars with expertise on the legal traditions of India working in Europe, Australasia, or the Americas could provide vital comparative and complementary perspectives. Collaboration on such scales requires funding and organization, as well as a willingness to undertake such projects in the first place, but shouldn't be discounted as a way forward. Collaboration on both small and large scales is clearly aided considerably by the new possibilities presented by online conferencing and the general improvement in communications and digital technologies. The latter in particular can be harnessed for legal history research and for making legal history more effective. Digitization of records hitherto imprisoned in archives can in itself be an enormously time-consuming exercise. The photographing of medieval court rolls in the National Archives at Kew in the UK as part of the Anglo-American legal tradition digitization project, for example, or the 18th century Old Bailey papers, which were put online a couple of years ago, enables a greater accessibility of these records to scholars from all around the world. Digitization of printed books and materials, such as newspapers, has also been embraced by a number of publishing groups, and it usually includes search functions. This inevitably assists the researcher who does not need to leave her desk in order to engage with historical sources. Translation of sources, where they are in ancient or non-native language, has also increased accessibility and thereby understanding. Coupled with the facility for translated texts and books to be available online, the effectiveness of undertaking research in arcane areas is multiplied. Finally, the possibilities of digital technology in creating immersive experiences through augmented and virtual reality enables enterprising researchers and organizations to bring legal history to life. This can be either undertaken as part of a project of recreation in what has become known as experimental archaeology, or as a source for visitors to particular institutions. My own institution, Historic Royal Palaces, has been in the vanguard of exploiting this technology for visitor attractions, notably in recreating as a sensory experience the trial and execution of King Charles I in the award-winning Lost Palace, set up around the banqueting hall, the last surviving part of Whitehall Palace. Similarly, they're currently developing, with myself as a consultant, an immersive experience for visitors at the old courthouse at Hillsborough Castle in Northern Ireland. Combining digital scenes with a reenactment that visitors can participate in as the accused or as members of the jury, they will be using the records of real-life trials to enable lay people to experience and appreciate the rigors of the legal system in a genuine historical law court setting. Care will be taken in the presentation of the legal profession and the historical contingency of the different types of cases. There will also be an element of choice on the part of the person experienced in court, which, if analysed, could also bring interesting data on how people react in certain situations and how they adapt to older ways of thinking about the legal system. I'm not aware as to whether there is anything similar envisaged anywhere in India, but this too could be an innovative way of exploring legal history, and one which would benefit researchers and tourists alike. I would, of course, be happy to be involved in developing any such projects. Finally, what does the effective approach advocate? It's the training of students in legal history. This begs the question of what does it mean to be a legal historian? As mentioned previously with regard to different approaches espoused, and I'm sure you're aware from students in your own institutions, legal history is taken by both law students and history students, sometimes by those from other disciplines too, who bring to it their own respective understandings. To be effective researchers, however, they need to combine the essential characteristics of the two, to be a hybrid, or at least to be aware of the pitfalls of adopting a monolithic approach to the subject. They need to be familiar with the legal rules and legal doctrine and be able to rise beyond mere description of historical fact. Ideally, they will be versed in social sciences as well as humanities and pathology, and able to bring critical perspective to bear. One of the benefits of the curriculum in many universities now is that the encouragement of gendered approaches, as well as lines of inquiry that can uncover hidden histories and hitherto obscured relationships or activities that have continued beneath the historical radar. The lines of what is legal or illegal are often subject to historical contingency, and thus a ripe subject for the legal historian. Indeed, legal history is potentially a very inclusive discipline with lots of people from all disciplines using it. So in conclusion, I've outlined the shape of legal history that legal history ought to be taking in the 21st century, and suggested that there is no more appropriate country with its complex historical trajectories and legal systems to be exploring this than India. By widening parameters, galvanizing research teams, embracing technology, and training its students as effective legal historians, many exciting projects could be realized. But legal history is capable of having more significance than just being effective legal history. It needs to be used to its full potential. In other words, if reformers and lawmakers considered using the tools, approaches, and methodology of legal history to explain potential future development and to predict it, this ought to make for more efficient lawmaking. I can't particularly speak for India, but the reason why there are so many faults in current lawmaking in the UK, I'd say parliamentary lawmaking, not necessarily judicial, is not just because of the political and legal imperatives which seem to weigh too heavily on Parliament, but because things are not thought through. There is insufficient time and insufficient care taken with legislation. Lawmakers in Parliament, as opposed to the judiciary, who often take a keen interest in the legal history of the law, are content to just get the law made as quickly as possible. They make a best guess at its effect and operation. Legal history can improve on the best guess as it can provide a more reasoned and more pragmatic and potentially more accurate prediction of its effect. Legal history can also be utilized to suggest reforms on the basis of an understanding of this historical, social, and legal context. It is not the answer to everything, but is a dynamic that should be reckoned with, bearing in mind that today's judicial decision becomes tomorrow's legal history. Thank you.
Thank you very much, Professor, for your enlightening speech. So we, the legal fraternity, try to introspect the law and other discipline, interdisciplinary approach, multidisciplinary approach, and cross-functional approach. Thank you, Professor. So it's indeed my pleasure to invite our beloved Vice Chancellor for the presidential address. A brief introduction about our Professor Vice Chancellor. Professor B.S. Elizabeth is the fourth Vice Chancellor of Tamil Nadu National University. She had a vast experience of more than 35 years, both teaching law, history, and feminist jurisprudence. Professor began her academic career as a part-time lecturer in history in 1984. Professor taught in Indiranagar Junior College, NMKRV College for Women, and worked as a full-time lecturer in the Department of History at the Maharani Lakshmi Ammani College for Women in 1986 and 87. Professor joined with a full qualification to teach law and history in the National University, Bangalore. An experiment in the legal education of India set up by the Bar and Bench of India. Professor designated and designed syllabus for teaching history in the 5-year integrated law degree programs. The same is followed in all the national universities and various state universities. Appreciating Professor's contribution in the family jurisprudence, in 2005, she was invited to join a group of law teachers from various parts of the world to form the International Association of Law School, and one of the founding members and governing body 2 times between 2005 and 9 and 2010 and 13. In 2012 and 13, Professor was appointed as a member of the high-level committee on status of women by the Government of India. Most of her publications are on themes related to law and violence against women. Professor is very passionate about her students and about history and women's right to live with human dignity. In 2010, Tekkan had described Professor's academic commitment with 3 S's: single, strong, and successful. Couplet from Tirukkural, தெரிந்த இனத்தோடு தேர்ந்தெண்ணி செய்வார்க்கு அரும்பொருள் யாதென்றும் இல், meaning there is nothing too difficult to be attained by those who, before they act, reflect well themselves and thoroughly consider the matter with chosen friends. So with this brief introduction, I'll request our Vice Chancellor to deliver the President's letters. Over to you, Professor.
Thank you very much. It's been indeed a pleasure to be listening to such erudite scholars like Professor Anthony Musin and our Chancellor, Justice Sanjeev Banerjee. I'm going to turn off my video because my phone heats up if I have both the video and the audio on, but you will. Oh, shucks, man. Yeah, I hope you can hear me. I'm sorry,
Yes,
it seems
yes,
to have
Professor.
gone into, yeah, okay, thank you. Thank you. Respected Chancellor, Justice Sanjeev Banerjee, respected members of our governing bodies, Professor Justice Sivagyanam, Mr. Arvind Datar, Ms. Chitra Sampath, Justice Lingeshwaran, Justice Prakash, respected Vice Chancellors, Professor N. Rajendran, Professor Vijay Kumar, Professor Bhatnagar, our keynote speaker for today, Professor Anthony Musin, who is also a good friend, Commodore Oracle Johnson, Professor Kota Fukui, Professor Kumkum Roy, Dr. Mahmood Kuria, Dr. Santosh Abraham, Professor Anandita, Dr. Richard Sharma, my colleagues, especially our registrar, Ms. Leela, without whose support and commitment to the university and to be such a strong background for me, I wouldn't be here today addressing you this morning. With great humility, I'm here to deliver this presidential address on this momentous occasion, something that I have been thinking about, planning for the last 1 year, and something that as a university we've been working on for the last 6 months. So thanks to the organizing committee of TNNLU and Dr. Richard Sharma for all their valuable inputs, which has made this program possible today, and also to Dr. Rohit Dey, without whose introduction to these eminent speakers and chairpersons, this program would not even have been conceptualized. I owe a debt of gratitude to several people who have made this day and this program possible. And not least of all is Almighty God, who has brought together all of us in spite of the pandemic situation in which we are. By his grace, here we are meeting online to listen to some of the best minds in the field of history and legal history in particular. Now, history and legal history have been taught, researched into, and written about for a long time by scholars from various parts of the world. And though history as a discipline has been well established and amongst the most advanced and scientific of all disciplines taught in this country, it has, however, not received the kind of importance and relevance that it should, given the fact that, as Professor Musin was just presenting to us, it enables us to understand the context in which law, policy, and the judicial system function. And when we look at legal history in particular, you find that it has been much neglected. Historians in general haven't given it as much importance as they give to the socioeconomic and political history of the subcontinent. Legal history has been pursued by very few historians, and some of them are going to be addressing us during this two-day Congress. For a long time, legal history was largely written about by retired judges and a few law teachers, with little to no foundation in historical methodology or the historical perspective. And as a consequence, it has been very narrowly understood. Besides which, of course, that it has been almost, completely neglected in the law colleges where it used to be taught. To study law without understanding the historical context, meaning the social and economic background in which law has developed, is to be ignorant of the reasons for the development of these laws and the legal systems and the success or failure of many of them. We can end up making the same mistakes like those in the past. In fact, as someone has said, to ignore the past is to repeat it. History is today being taught and studied in most of the law colleges and law universities in India, but it is yet to gain the importance in the eyes of the law students and law teachers. As a result, the wealth of information awaiting serious research is yet to be fully tapped into. Historians, on the other hand, have tended to focus more on society and economy of the past, and even when some of them do deal with the polity and administration, still ignore the development of law and the judicial institutions. There are very few historians, as I mentioned earlier, who actually look into the development of law, the legal system, and the judicial system. When they do write about law and the judicial institutions, many historians do not look into or look for information on what existed. They rely on the prescriptive texts. And as a result, we continue to be largely ignorant about the nature of justice that actually prevailed in the ancient and medieval times, or even to some extent in the colonial period. Most of what we do know has been culled out from the work of foreign scholars, scholars in America, scholars in Britain, scholars like Henry Maine, J.D.M. Derrett, Alan Gledhill, and others like them who have delved into the history of the Indian subcontinent at great length. Legal history in particular is what I am here referring to. On the other hand, we have not been able to, excite historians or legal scholars about the legal history of India. There have been, as I mentioned, too few of them, like Professor Farhat Hassan, Professor Chandni B, Dr. Santosh Abraham, Dr. Mahmood Kuria, and others who will be sharing their research and their writings in the course of this Congress. I'm also proud to say that in this context, that the National Law Universities, particularly the National Law School of India University, has produced two graduates, Dr. Rohit Dey and Dr. Kalyani Ramnath, alumni of NLSIU, who went on to graduate from Yale Law School and then pursue PhD in history, and who today are teachers of legal history at Yale and at Harvard. And they have been able to bring a new direction to the understanding of legal history of India and South Asia through their works. It is this kind of an interdisciplinary approach that I'm looking for in the pursuit of legal history, for it to be meaningful for the students and practitioners of law, because it has to be researched about, written, and taught by those who have studied both history and law. Because without that kind of background, to understand the nuances in the development of the legal system cannot be done by someone who doesn't understand how the law and the legal system work. At the same time, without the tools and skills that someone who has been deeply immersed in the discipline of history, you cannot really study the legal history. All you end up doing is only reading the secondary sources. The 5-year undergraduate program that has come in since 1988 provides all of us the opportunity to explore this interdisciplinary approach with all the necessary skills and perspectives, if we can only be open to the possibilities and be excited by what we learn and that is before our eyes. The NLUs have a big role to play in this, as they claim to be using an interdisciplinary approach to the study of law, which after nearly 30 years at the National Law School, Bangalore, I can say is really very far from the truth. The organization of the All India Legal History Congress is truly the first initiative, in all honesty, to take the first step in the direction of the interdisciplinary approach by combining the tools, knowledge, and skills of history and law. And for this, we have Dr. Richard Sharma of GNLU to thank, who through her own teaching, and her short career, realized the need for something like this. But this effect too has come in from those teaching history rather than from the law teachers. I hope that the hosting of the All India Legal History Congress by different law universities in turn will lead to a healthy interaction between these two disciplines and encourage as well as motivate students and teachers of law to look for the riches that await them with regard to understanding many of the legal problems that beset our country today, but deeply rooted in the history of the society, economy, culture, and religions of our very rich and diverse country. Amongst those who have recognized the invaluable wealth in legal history were feminist historians who sought to understand the so-called socio-religious reforms of the 19th century, which were carried out through legislations, and understand the status of women. Scholars like Lucy Carroll, Professor Janaki Nair, Prem Chowdhury, Lata Mani, Rosalind O'Hanlon, Professor Kumkum Roy, and many others use their feminist methods to demonstrate how women were not even the subject or object of these socio-religious reform laws, like the Hindu Widow Remarriage Act or the Sati Prohibition Act, or even the Child Marriage Act. Though through their research and writings, they explored the impact of the policies on women, how Devadasis were reduced to prostitution by the colonial codes and legislations in order to make way for colonial advancement, and how the Sati debate was more about good and bad tradition rather than about how it impacted women. While others like Professor Janaki Nair and Flavia Agnes showed how our women's rights of succession, inheritance, and title to property was slowly undermined and ultimately done away with through colonial law and policy and practice, which took away the recognition of customary law that prevailed in communities prior to the colonial period. All these scholars have contributed immensely to our understanding of the status of women then and now. It is this kind of interdisciplinary approach that I'm looking for in all areas of our study of the law and the past, so that our knowledge and understanding of our present society and the way forward into the future could bring about a society closer to the constitutional values reflected in the preamble to our Constitution. I hope that the papers that are to be presented over the next 2 days will not only shed light on our past, but more than that, will motivate each one of us to develop a healthy respect and interest for each other's discipline, and ensure that legal history grows as a discipline. Thank you very much.
Thank you so much, Professor, for the enthralling presentation and touch of the perfection. So we, the Tamil Nadu National University fraternity, will assure the initiative whichever you made, it will go and it can be make strength in the future course. Without much further ado, I would invite Ms. K.R. Leela, Senior Judge and Registrar of Tamil Nadu National University, to propose formal vote of thanks. A couplet from Thirukural: Tinai Tunai Nandri Seyinum, Panai Tunaya Kolvar, Payan Teriyar, meaning, though the benefit conferred be as a small as a millet seed, those who know its advantage will consider such a large farmer of root. Over to you, ma'am.
Good morning, everyone. It is my proud privilege to express the vote of thanks on this special occasion. First and foremost, I apologize for the extension of the program beyond the time schedule. but I have to do my duty and express a vote of thanks. First of all, on behalf of the Tamil Nadu National Law University, I thank our Honorable Chancellor of the university for having kindly accepted the invitation of the Vice Chancellor to be the chief guest of the inaugural function and to release the journal of the first All India Legal History Congress and also to deliver the chief guest address. I thank your Lordship for the gracious support extended to the university by sparing valuable time for us and beyond the time schedule that too. I particularly thank your Lordship for the lesson in humility and the lesson in judicial and also for highlighting the importance of precedents and for the study of history of each legislation for better understanding of the law. Thank you, Lordship. Next, I thank the Pro-Chancellor of the University and the Government of Tamil Nadu for granting a generous grant to sponsor this Congress. I next thank our Vice Chancellor and the patron of the Congress, Professor Dr. V.S. Elizabeth, whose vision and determination has brought us to the threshold of this Congress. I thank you, Professor, for your continuous support, guidance, and encouragement in organizing the Congress, and also for delivering the presidential address today. I further thank all the members of the General Council, the Executive Council, the Finance Committee, and the Academic Council of the University for their continuous encouragement and confidence reposed in us. I particularly thank Honorable Mr. Justice Shivanyanam, Honorable Mr. Justice P.N. Prakash, Ms. Chitra Sampath and Mr. Arvind Dattar, senior lawyers, and the Director of the Judicial Academy, the District Judge, Mr. Lingeshwaran, for taking the trouble and the time to join us here today in this inaugural function. Even though we have run out of time, I would like to mention here particularly the contribution of the Executive Council member, Honorable Mr. Justice T.S. Shivanyanam, to law and history in his own particular practical way. Lordship has been instrumental and most particularly personally interested in restoration of historical judicial buildings in the state of Tamil Nadu. Particularly, there is a building called as a horse stable court in the city of Coimbatore in Tamil Nadu. I believe before the advent of the motor vehicles, horse carts and bullock carts were used for transportation of human beings. And whatever offenses were committed by those horse carts, they were tried at a stable. And that was the stable court, and it was in ruins. And His Lordship, by personal and direct interest and supervision, has arranged for the restoration of that historic court building in Coimbatore. That is the Lordship's personal contribution to history and law. And I have to mention also that His Honorable Mr. Justice P.N. Prakash is particularly interested in the Chola history, and he has expressed his interest in joining the participating and viewing the paper presentations relating to Chola history. And I have to thank Mr. Arvind Dattar and Ms. Chitra Sampath, very busy and senior lawyers, for taking the time out to join us in this inaugural function and for supporting us in this Congress. I also express my special thanks to Dr. Richard Sharma for her support and guidance to the organizing committee to bring about this event to a successful inauguration. And I have to express a very special thanks to Professor Anthony Moosen for immediately accepting the Vice Chancellor's invitation to deliver the keynote address this morning, and for going that extra mile to wake up at a very early hour today to be with us today. Thank you, Professor. I also thank the various chairpersons of the sessions, namely Professor Anindita Mukhopadhyay, Professor Dr. N. Rajendran, Dr. Julia Stephens, Professor Dr. Kumkum Roy, Professor Dr. V. Vijay Kumar, Professor Dr. Farhat Hassan, Professor Dr. S. Anandi, and Dr. Aparna Balachandran. I further thank the lead speakers, Dr. Santosh Abraham, Professor Dr. S. Chandini B., Dr. Kalyani Ramnath, Professor Dr. Donald R. Davis, Dr. Rohit Dey, Dr. Mahmood Kuria, Professor Dr. Janaki Nair, and Dr. Richard Sharma. I thank all the chairpersons and the lead speakers for having kindly accepted our invitation to be the chairpersons and the lead speakers in the forthcoming sessions. I have to thank the organizing committee members of this Congress who have met not less than 18 times in the last 6 months to plan meticulously and execute the Congress. Thank you one and all. I also thank the student volunteers and the faculty of the university for extending their support and help in various ways. I thank the participants, the faculty, the students, paper presenters, research scholars, the administrative staff, and the IT team of the university, and also the IT team of the Madras High Court for the participation, support, and help extended to each and every one of the organizing committee members to bring about the inaugural function and to conduct the event, the Congress, in the forthcoming 2 days. I also thank the press for having covering this event. And I have to mention a special thanks to District Judge Mr. Sarona Kumar, the IT Registrar of High Court, for coordinating the inaugural function from his end. Thank you, sir. I once again extend a heartfelt thanks to each and every one of you for taking part in the inaugural function and the Congress during these catastrophic times. Thank you one and all for being here and supporting us in this event. Thank you.
Thank you, ma'am. To be successful, you must surround yourself with right people. This inaugural event of the second All India Legalistic Congress is successful with the great leadership of our Vice Chancellor and the Principal Executor, Richard Sharma, and the fellow followers, the organizing committee, faculty, student volunteers, IT committee, and all the administrative staff of TNLU. We, the Tamil Nadu National University faculty, strive to develop a knowledge-based society with clarity of thoughts and charity of hearts, committed to serve humanity with integrity. We, the Tamil Nadu National University community, would like to express that had it not been pandemic crisis, everyone would be adored an academic ambience of TNLU in the temple city of Tiruchirappalli. So we request all the participants and delegates to rejoice the academic gathering today and tomorrow. We invite you all to the Tamil Nadu National University, TNLU, in the near future academic events. With this, I request all the delegates and participants, and ladies and gentlemen, please rise for national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you very much, Honorable President here. Thank you, Lordships, and thank you, Keynote Speaker. Thank you, President, and all the other delegates. Thank you. So I request all the participant delegates, please join this session as it was sent by the organizing committee. The session will start as per the schedule. So thank you very much.